The legal struggle between NASCAR and its teams, 23XI Racing and Front Row Motorsports, has taken a significant turn against the governing body. The new verdict by Judge Kenneth D. undermines NASCAR's defense methods, exposing fundamental errors in their claims and potentially creating a precedent for antitrust law in racing. The disagreement centers on NASCAR's rejection to sanction FRM's acquisition of a charter from Stewart-Haas Racing, which was most recently linked with the number 10 car. Despite NASCAR's objections, Judge Bell ordered that the deal be approved immediately, leaving NASCAR out in the cold. This could turn the whole case upside down. Judge Bell rejected NASCAR's request to postpone the decision, underlining that the sanctioning organization had adequate time to make its case. He further disputed their claim that the clearance could not be reversed if an appeal was successful, noting that NASCAR had previously indicated assent to the transfer before FRM filed its action. One of the most devastating aspects of Bell's decision concerns NASCAR's release clause, which prohibits teams from suing the company. Bell described the clause as anti-competitive and likely in violation of federal antitrust laws, writing, "NASCAR's release-to-race requirement simply doesn't pass muster and is likely to be found to violate antitrust law." The judge also pointed out NASCAR's inconsistent claims about the release clause. On the one hand, NASCAR stated that 23XI and FRM couldn't sue since they had not signed the 2025 charter agreement. NASCAR, on the other hand, claimed that by accepting the agreement, teams waived their right to launch antitrust lawsuits. Bell addressed this logical inconsistency, stating, "Plaintiffs or any other team that wanted to challenge NASCAR's conduct as an antitrust violation is put in a classic catch-22. The team must accept the 2025 charter agreement, including the release that bars plaintiffs' antitrust claims. But if it doesn't sign the charter agreement, then it can't bring those same antitrust claims because it doesn't hold a charter." NASCAR's case was mainly based on concerns that allowing 23XI and FRM to race under the 2025 agreement would result in irreparable harm. Bell undermined this argument, citing NASCAR's own appreciation for the charter system. NASCAR shares the same terms with 30 other cars and has consistently stated before the court that those terms represent a fair and advantageous contract for all parties involved. Thus, the court's injunction ordering NASCAR to allow plaintiffs to race chartered vehicles cannot cause irreparable harm to NASCAR. The judge also addressed NASCAR's worries about sharing confidential information with the two teams, dismissing the claim as meritless because the teams would already have access to such information during discovery for the trial. Judge Bell noted that the verdict is in the fans' best interests, maintaining competitive parity by allowing all top-tier teams and drivers to compete in the 2025 season. It is in the public interest of the consumer, which is the fans in this case, that all the best cars and best drivers are represented in every race next season. As this dispute progresses, NASCAR faces an uphill battle until Bell's ruling is resolved. Their attempt to enforce the release clause has backfired, exposing the group to additional legal scrutiny. Bell's unequivocal rejection of their arguments on numerous fronts shows that the court believes the club's antitrust concerns are valid. As the trial approaches in December 2025, NASCAR must not only prepare to defend against antitrust claims, but also deal with the immediate consequences of Bell's injunction. The governing body's legal position appears to be deteriorating, and the outcome of this action has the potential to transform the sport's governance structure. The ongoing antitrust case filed by 23XI Racing and Front Row Motorsports against NASCAR might have far-reaching consequences for the sport. If the teams win, the case, which revolves around NASCAR's charter system and its contentious release clause that prohibits teams from initiating lawsuits, calls into question the basic basis of NASCAR's governance scheme. A victory for the plaintiffs would most likely result in radical changes to how NASCAR functions, significantly altering the sport's power dynamics and economics. The charter system, which guarantees teams' entrance into NASCAR races as well as a percentage of income, is central to the complaint. If 23XI and FRM win, the system may undergo a thorough revamp. Judge Kenneth D. has already argued that the release-to-race clause, which precludes teams from filing lawsuits, is likely anti-competitive and violates federal antitrust statutes. A verdict in favor of the teams might force NASCAR to completely abolish this restriction. Teams may acquire more liberty in shifting charters without seeking NASCAR approval. This would result in a more open and competitive marketplace, allowing smaller teams to prosper while decreasing NASCAR's centralized control over team operations. A victory for 23XI and FRM could inspire other teams to seek greater autonomy from NASCAR. Currently, NASCAR exerts extensive control over team operations through charter agreements and other regulatory procedures. A victory for the plaintiffs could result in the flexibility to negotiate sponsorships and agreements. Teams may be able to negotiate more lucrative deals without fear of interference or veto from NASCAR. Teams may be motivated to dispute other potentially restrictive NASCAR laws, such as income distribution or race schedules. A decision in favor of the teams could push NASCAR to reconsider its revenue-sharing formula. Teams have long claimed that the existing distribution structure disproportionately benefits the sanctioning body and track owners. A favorable verdict could result in a bigger revenue split for teams. Teams might earn a greater share of TV and sponsorship revenue, making the sport more financially viable for smaller teams. If revenue distribution is more equitable, clubs may rely less on external sponsorships to cover operating costs. NASCAR has historically been a centralized authority, imposing rules for teams, drivers, and sponsors. A legal defeat could undermine this power. NASCAR may be obliged to take a more collaborative approach, incorporating teams in decision-making processes in order to avoid future legal conflicts. The lawsuit alleges a lack of openness in NASCAR's governance. A victory for the plaintiffs could result in improvements that make NASCAR's decision-making procedures more transparent and accountable. The outcome of this case may set a legal precedent for other motorsport leagues worldwide. If 23XI and FRM win, it may motivate teams in other series to challenge restrictive practices by their respective governing bodies, thereby changing the global motorsport landscape. Judge Bell underlined the public interest, adding that viewers are entitled to see the top cars and drivers compete. A decision in favor of the teams could improve competitive parity by lowering barriers to smaller teams competing effectively. Fans could see more diversified and competitive racing. Legal improvements might help NASCAR's reputation, particularly if the lawsuit resolves long-standing concerns about fairness and openness. If 23XI Racing and FRM win the case, NASCAR's governance and commercial model may be drastically impacted. While such reforms may cause some disruption at first, they have the potential to create a more egalitarian and competitive environment for teams, drivers, and spectators. However, the trial is scheduled for December 2025, and the path to resolution will surely be paved with additional legal tactics. The way NASCAR responds to this watershed point in its history will determine whether the sport emerges stronger or suffers from chronic turmoil. A victory for 23XI Racing and Front Row Motorsports in their antitrust complaint against NASCAR would be a watershed moment for the sport, paving the way for a new era of transparency, justice, and competition. So far, Judge Kenneth D. Bell's findings have shown fundamental weaknesses in NASCAR's claims, while also shedding light on systemic concerns within the organization's governance structure. If the plaintiffs win, the removal of the contentious release clause and a revamp of the charter system may allow teams to operate more freely, negotiate better sponsorship deals, and compete on a more level playing field. This would solve long-standing concerns about NASCAR's centralized influence over its members, potentially resulting in revenue redistribution that benefits smaller teams while also promoting financial sustainability across the grid. Such a decision might also have an impact beyond NASCAR, setting a precedent for antitrust legislation in motorsports and prompting other teams in worldwide racing series to challenge restrictive actions by their governing bodies. While the immediate consequences may entail operational disruptions and modifications, the long-term rewards could result in a revived sport in which fan interests are emphasized and the competitive field is expanded. Fans would see the best vehicles and drivers compete without artificial barriers, increasing the thrill and unpredictable nature of each race. However, the path to this possible future is filled with uncertainties. The trial, slated for December 2025, will determine if these radical changes take root or whether NASCAR can continue in its current form. Regardless of the verdict, this case highlights the importance for motorsport organizations to adapt and change in response to increased demands for equity and accountability. Finally, the outcome of this legal struggle has the potential to change not only NASCAR, but also the essence of racing governance. What do you think? Will the teams end up winning the case? And will this have a major impact on NASCAR in the future? Let me know your thoughts in the comments down below.